for
Nsem-Pii will honor more. Now Nsem so it is. Utie now share on my YouTube channel.
Be the first to know. Nsem-Pii.
Supreme Court and a panel of 5 judges presided over by Her Ladyship, the Chief Justice, Gertrude Saki Tokono, etnasi hearing a friend say application ababeda in Supreme Court from Nipa Mino, Richard Delaskai, our new journalist, and office Dr. Amanda Addo, our no a pro-feminist group be or more a leader, regarding the constitutionality of LGBTQI plus bill Parliament appropriate some months ago. Rebecca years I believe Nsem-Pii by Koya to the extent say Speaker of Parliament and no more bufu say another Kwakufodo and Fanensa and Shasi Intino. What Jene Parliament Sinedi Parliament for over months near Tenasi and can somewhere was here can engineer was here to Emagana and Puntu Timikoso. And on a nay Supreme Court etnasi ni Dr. Amanda Addo and also the lawyers on case on the ababed down after CAT the last kind and Dr. Amanda Addo lawyers changed Supreme Court panel of 5 no emergencies to say Ghana mra bad time and the constitution ni say and sana parliament ebe pass any bill bia no beje bill bia to na baba mra Ghana hano. There is one element of emrana also hwehwemu to the extent say gitum say Sam Brano has been met and sana ya jiatum e de akodan president. I'm a president I sign the signature. I'm an abedimra. And none section 100 of constitution no I say bill biano and was say you carry out a physical and regulatory assessment near hwehwem ensunsuanso ben and asa bill no ebeye mra ebenya ewo amanfo so nipa so benya wo dwumadie so ebenya wo say bibia ekoso manimo. Amanda Addo lawyers say sadly we say Parliament of Ghana didn't do it, and the records in the House of Parliament show say they didn't put the bill through those processes. And now some George Mudi trying to score political points in or more educated tuma Bagbin etaumechi. Na Adam Kwakufodo and need yedene bo emano esan say or two no say there be one fan and saying secret ebiase. In some no court in Shiana court in determine and court to Kushia no ada di pefi said you here no na ene kwanso ano no na case was telecasted live for everybody to see and Nsem-Pii TV and sa kan footage ni bia lawyer for plaintiffs no or the Nsem tudwa Supreme Court judges no engage na nya de oka no muntiase amomehunu sampa. The Parliament of Ghana erred in the processes in adopting this LGBTQI plus bill. Yenhwe said ye ne na Supreme Court isi ehuruso.
Parliament was caught by, or the person presiding was caught by Article 108 I, and then I.
Roman 1, Roman 2, Roman 3.
Roman 2, Roman 3. Lady, despite the limitations imposed on the
Parliament was
caught. Yes.
C-A-U-G-T.
By the provisions of Article 108.
What does court mean?
What we mean is that there were limitations placed by the Constitution on the exercise of the powers of the person presiding. And so these constitutional limitations were supposed to constrain Parliament from proceeding any further with the bill. But that was not the case. The bill proceeded. And
Council, can you explain what the limitation you are talking about is, please?
My lady, respectfully, the limitation is simply that Parliament shall not proceed if a bill is not introduced by the President. Then, if a private member introduces the bill, then there should be prima facie an analysis of the bill to see if it imposes a financial implication on the public purse. If it does, then Parliament cannot proceed. That is the meaning we place on Article 108.
Your summary seems to skip a few salient points. Can you quote what the Constitution says in that regard?
It says that Parliament shall not proceed if the bill imposes a charge on the consolidated fund or other public funds of Ghana. That is 108A Roman number 2. That is what it says.
You read more than that, Counsel.
Yes, but
can you give a faithful rendition of what the Constitution says instead of just picking and choosing?
So Roman, to go back to your submissions, A says that Parliament, 108 says Parliament shall not, unless the bill is introduced by the President. And A says that proceed upon a bill, including an amendment to a bill, if in the opinion of the person presiding makes provision for Roman 1, the imposition of taxation or the alteration of taxation, otherwise than by reduction. What does that mean? I believe that's the question being asked.
yes, we are not grounding our case on AI, but on number 2 and 3.
And 2 reads.
2 reads the position of a charge on the consolidated fund or other public funds of Ghana, or the alteration of any such charge otherwise than by reduction. And
does the 2 stand by itself, or it is controlled by the part that was read by her ladyship?
yes, my lady, it is controlled by the preceding paragraphs.
Give a faithful rendition of it so we follow your argument.
In my own words, or I should read from the Constitution?
Just to assist, Parliament shall not, unless the bill is introduced or the motion is introduced by on behalf of the President, proceed upon a bill including an amendment to a bill that, in the opinion of the person presiding, makes provision for any of the following. And you say you are grounded on Roman 2.
Yes.
The imposition of a charge on the consolidated fund or other public funds of Ghana, or the alteration of any such charge, otherwise than by reduction. So,
And then 3.
what does this mean?
Lady, what it means is that if a bill is introduced in Parliament, which is not by the President, there must be a fiscal impact analysis. So the fiscal impact analysis must accompany the bill. And then based on that fiscal impact analysis, the person presiding looks at it and say, if the bill says we are going to arrest and detain people, even the pre-trial processes will incur some cost. And so, if that analysis is done, and it accompanies the bill, then the person presiding is in a position to say that this bill cannot proceed. It being coming from a private member, but not the President. Because the essence of the law is that Parliament checks the public purse, but it does not spend the public purse. It does not tell the executive how to spend the money of the country. It is the executive that decides to spend, and Parliament acts as a check. And so this provision is acting as a check or a limitation on members of Parliament that want to rule the country from Parliament. It is the executive that rules, not Parliament. And so the essence of the bill is saying that if you want to introduce a bill, that is fair enough, but make sure that that bill does not impose a charge on the public purse, because the executive that determines how the money of the country is spent. And so if a fiscal impact analysis is placed before Parliament, the person presiding does not make an opinion arbitrarily, but in a fair and candid manner to say that I am guided by this, it imposes a charge on the consolidated fund, and therefore we shall not proceed with this bill.
Really? So how does what you have read tie in with the specific facts of this case? That is what I think we...
Yes, my lord, the specific facts of this case is that when the bill was first introduced, there was no fiscal impact analysis. When it was first read, it was referred to the Constitutional, Legal and Parliamentary Affairs of Parliament. So the Constitutional and Legal Committee sought the opinion of the second respondent. And the second respondent in a letter...
In the Attorney General.
The Attorney General, my lord. And in a letter dated the 19th of October 2022, with reference number LI 7/2021, the Attorney General, specifically on page 5 of that report, clearly stated that it is observed that the bill...
I don't like the language. Did you say observed or absurd?
Really, I'll read it for you.
Read. Exhibit.
This is exhibit A1.
Yes.
Really, and it is paragraph 1, 2, 3, 4, 5, 6.
Paragraph 6.
Paragraph 6.
On page
5. And the advice reads, it is observed that the bill is not accompanied by a fiscal impact analysis required by section 101 of Act 921. The stipulation in section 101 of Act 921 is rendered more imperative by the character of the bill as a private member's bill. So this is the advice as attached to exhibit A1. Yes, my lord.
Observation is the advice?
It's an observation, but it goes on to say, it analyzes the bill one by one, and then even before this paragraph, the advice says, that is paragraph, starting from paragraph 3. It says, thus, the passage of the bill is subject to subparagraph 3 of paragraph A of Article 108 of the Constitution. A determination of the satisfaction of the conditions in Article 108 ought to be made objectively by the person presiding over proceedings in Parliament on the basis of analysis properly conducted by proponents of any bill in question. And it goes on, it is for this reason that section 101 of the Public Financial Management Act 2016 stipulates that any legislation to be laid before Parliament or proposal submitted for the approval of Parliament shall be accompanied by a fiscal impact analysis stating the estimated effect on revenue and expenditure for the financial year in which the legislation or proposal is expected to come into effect. My lords, what we are saying is that despite this advice, the bill proceeded in Parliament, despite also the pendency of this application or this writ which was issued on 1st June 2023 before you. Lord, the bill proceeded, and at various times there were statements to the effect that Parliament will pass the bill willy-nilly, despite the advice and despite the pendency of this suit. My lords, we are aware, I'll turn to our statement of case. As I've noted earlier, we rely on our statement of case, which is an 80 paragraph statement of case. But we also wish to make a viva voce explanation of the points we have raised. And my lords, I want to tie it in with the response by the first respondent, because we are going to argue that the conditions for the grant of an injunction to restrain the Impunity Act is rife, it is present, and we'll tie in it with the response or the affidavit in opposition by the first respondent. My lords, the affidavit in opposition filed by the first respondent on 20th May 2024, pursuant to the order of this court on May 8th, 2024, is not accompanied by a statement of case. The statement of case was not filed, but the first defendant respondent attacks our application, and we sum their attack on our application on 5 major grounds. First, that the present application for injunction is materially the same as the application which was dismissed by the court on 19 July 2023. They state that in paragraphs 9 to 18. Secondly, they say the President has expressed an unwillingness to assent to the bill, paragraphs 19 to 22. They also talk about the fact that the grounds for the...
To 9 to 18.
Yes.
The essence of paragraphs 9 to 18.
Yes.
Can you go back to that?
Yes. The point we are making is that their claim, or in sum, what they are saying in paragraphs 9 to 18 is that the present application for injunction is materially the same as the application which was dismissed by this court on 19 July 2023. Then, in paragraphs 19 to 22, paragraphs 19 to 22, the essence of what they are saying is that the President has expressed an unwillingness to assent to the bill. That is paragraphs 19 to 22. Then they go on to say in paragraphs 29 to 30 that the grounds for grant for an order of interlocutory injunction have not been proven by the applicant. And then finally, in paragraphs 23 to 27, they say that a report of the committee indicates that the AG's concerns have been addressed. 23, my lady, to 27, they allege that the report of the committee indicates that the AG's concerns have been addressed. And one final point, they also claim that the fiscal impact analysis has been conducted. Paragraph 28. Lord, it is this that we now turn our attention to respond to and then tie it in with our own legal submissions. My lords, the first point that the present application is materially the same as the previous one is inaccurate. At the time of the hearing of the first application for injunction in July 2023, the bill was still being considered in Parliament, and indeed we have attached Exhibit A2, which suggests that the Speaker had directed that the bill be considered either on the 23rd or the 27th of July, despite the pendency of the writ and the application for injunction. Lord, at the time of filing this present application, the work of Parliament in terms of considering the bill is completed, and Parliament has attempted to transmit the bill to the President. And my Lord, our point is that there is a changed circumstance, a material change circumstance, in fact and in law, and the fact that a previous application has been dismissed does not prevent us from bringing another one if the material facts have changed. And indeed, we are fortified by the case of Ajekum versus Asekum Engineering and Construction Limited. Ajekum versus Asekum Engineering and Construction Limited. Lord, is a 1989-1992 Ghana report at page 650. Lord, and clearly this court made it clear that the fact that an application has been dismissed earlier doesn't mean that when the change, there are circumstances that change, another application cannot be brought before the court. Lord, if I may read what this court said in that case at page 650. You see,
Page
650. Lord, the court said.
Did you say 650?
650, my lady. It reads.
No, the citation I got from you.
Yes, my lady.
Is 2 GLR at 250 or 650?
650.
Glory.
650. Now, this is what this court said. It said, it has been known, indeed, it's on page 5 of 15 of our statement of case. It says, it has been known for rulings in interim injunctions to be changed in the course of the same case, when the change is warranted by changed circumstances or on the occurrence of new matters. For example, a refusal to grant an application at one stage may, on repeat application, specifying changed circumstances or new matters, especially as to balance of hardship, be reversed and application granted. Unquote. Then we move on to the second point canvassed by the first respondent. And it is that the president has expressed an unwillingness to assent to the bill. My lords, nothing is further away from the truth than this. The statement of the secretary to the president, as captured in Exhibit 2 of the first respondent's affidavit in opposition, is to the effect that the president will not take any steps in respect of the bill until the injunction application is determined, so as not to undermine the authority of this court and prejudice the application. Note, the relevant portion of the statement is as follows, and it's paragraph 3, line 7 of the letter signed by the secretary to the president. And it reads, indeed, it is settled law that during the pendency of an interlocutory injunction application, the status quo ante ought to be preserved, and no action should be taken that will result in prejudicing the injunctive relief sought and undermining the authority of the court. Now, this is what it says. The president or the secretary to the president never said the president has expressed an unwillingness to assent to the bill. So that claim is factually inaccurate. Lord, thirdly, the first respondent argues that the grounds for the grant of an interlocutory injunction has not been proven by the applicant. Lord, it is our contention that we have proven all the elements for the grant of an injunction in paragraphs 33 to 75, paragraphs 33 to 75 in our statement of case in support of the injunction application.
Be the first to know Nsem-Pii TV.